Sebastian Corla. Like most, I would welcome this bill with a few reservations. While it is a positive attempt to foster better relations between employer-employees and their representatives, this bill does contain a number of shortcomings. Fundamentally, the bill does not increase the obligation on the employer to recognise the role of trade unions in dispute settlements. And while we are told that this is due to a Supreme Court ruling in Ryanair v IALPA decision in 2005, which deemed it was unconstitutional to force an employer to recognise a trade union, I wonder, is that really what this case turned on? Because we're constantly told that we can't introduce any form of rent control in this state because of a Supreme Court decision in relation to an act from the 1960s. But when you actually look in detail at it, that's not what the act was ruled unconstitutional for, and it's very limited. So I wonder, just is the government really looking to engage with this issue? And I still feel there are other ways to normalise employer recognition of representative bodies representing the interests of employees. In the UK, the Trade Union and Labour Relations Consolidation Act 1992 includes a duty to bargain and in good faith, and obliges the employer to disclose certain information to trade union or worker representatives. Even without forcing the employer to deal directly with trade unions, it's very possible to foster a more cooperative environment which would in turn lead to more resolutions. I also want to talk today about non-unionised workers, who I deal with a lot in my constituency in Donegal. Seasonal work is a large source of employment in Donegal, and indeed the only source of employment for many workers, especially among farmers and fishermen. Often they are on call, have zero-hour contracts, low-hour contracts, or are engaged in casual contracts. They might be reliant on social welfare payments for the other half of the year to supplement their income, or they might return to other seasonal work such as farming. Budgetary cuts introduced by this government over the last number of years have left the situation for seasonal workers in an even more precarious situation. because of the lack of work available to them and the lack of hours available to them, they are unable to maintain their social welfare entitlements. Workers like this are now dubbed the precariat due to the precarious nature of finding work. They find themselves in a very unique situation to most other employees across the country and in other sectors, and they are vulnerable to exploitative work practices in the industry in which they work. Seasonal workers work on-call shifts, and employers are obliged, in theory at least, to compensate workers who are required to be on call but are not used for work. Under the Organisation of Working Time Act 1997, workers must be paid for 25% of the hours when they were on standby, or paid for 15 hours, whichever is the least. However, this is not always the case, and many workers find they are not given what is due to them. Furthermore, these compensatory measures do not extend to casual work contracts. I would be interested to know how this bill would increase protection for those in precarious work, and ultimately the level of enforcement allocated to ensure compliance by employers. While the bill sets out mechanisms for employers, employees and trade unions to engage on terms and conditions, and where employer engagement is non-existent, the trade union can make a request to the Labour Court to investigate the dispute. There is little focus on the non-unionised workers. The bill does address exempted bodies which are non-unionised and who have a representative that puts forward the issues of the workers employed in the same company. The bill does outline the factors that the Labour Courts must take into account to determine whether a body is in fact independent, elements such as the election of representatives, voting, financing, number of meetings, etc. And the employer will have to prove that it does not have control over the negotiating body. But my concern is that the legislation does not apply where the number of workers party to a trade dispute is insignificant, having regard to the total number of workers employed by the employer, unless exceptional and compelling circumstances exist. If collective bargaining is a right, those workers who are a minority in their workplace are not in fact entitled to this right. And I do know from personal experience that many small groups of workers working within a single employment have actually changed conditions for their work colleagues because of the fact that they were willing to step forward and take cases to tribunals and fight for their rights. But they're left in a very vulnerable position, and they're left in a position that they have to represent themselves. And this is where the issue of victimisation is a relevant one, because behind the scenes in workplaces there are many different types of intimidation and ways to discourage the organisation of workers. Especially in the fishing industry, you may be silently blacklisted from working in the sector if your name is known around the place, and you are known to have tried to organise workers, join a union or attempt to resolve an issue. Practice is not too unfamiliar from the 1913 lockout. The bill claims that it strengthens the protection of employees from victimisation by their employers. such as the provision of interim relief in the case of a dismissal and enhancing protection of workers who feel they are being victimised. However, it's fine introducing legislation to try and strengthen the rights of workers, but the real issue is enforcement. Regardless of this compensation, trying to enforce these labour laws is another issue. It is a positive move that in this bill any determination by the Labour Court may also be enforced by the Circuit Court should any employer refuse to engage. But in the first instance, it's on the workers who are in very vulnerable situations to come together to actually get to the Labour Court in the first place so that they can get a recommendation that will be enforced. And the Circuit Court, in terms of enforcing Labour Court recommendations, isn't available to these workers because they don't have the funds to go forward. I'm aware of cases where the tribunal ruled in favour of workers and redundancy payments in Donegal, but yet the employer took the case to the Circuit Court, and because the employees couldn't afford to be represented, the case was lost. There we go back again to the fact that these are non-unionised workers. They don't have a trade union to represent them. So how can they actually avail of it? So this is the key focus of it. Actually, we do know that trade union membership across the country is declining, and very many workers in rural areas aren't represented by trade unions, and the trade unions have been very slow in actually attempting to organise those workers as well, because I don't believe they've been up for the fight.
Thank you, Deputy.
So legislation alone will not tackle the culture of exploitation evident in some workplaces, and it will not tackle the level of vulnerability some workers to exploitative practice. Enforcement needs to be part of the solution, and unfortunately, I don't have much faith in the enforcement aspect of this.
Come here, Monmouth, and I'll call Deputy.